Biggest gun ban going away? Assault weapons update. Say the Supreme Court actually strikes down assault weapons bans nationally sometime next year. What happens the next day? Not in theory, not in the abstract, but specifically in the roughly dozen states currently defending these laws, each with its own legislature, its own attorney general, and its own specific political coalition that fought for the original ban in the first place. Do they just give up? History says no, and not just in this specific area of law. Every single time a court has closed off one specific regulatory tool in this area, states that wanted to keep some version of that policy have pivoted to a different tool instead. Not always successfully, but predictably enough that the pattern itself is worth understanding before it happens again. Let's walk through exactly what that pivot has looked like before, and what it is already starting to look like now, before the Viramontes ruling has even come down. Quick thing before we get into it. I track how states actually respond in real documented legislative and regulatory action when a court closes off a specific policy tool, not vague speculation about what might happen based on nothing more than a general sense of how politically motivated actors typically behave. If that is useful, subscribe and turn on the bell. 2 seconds, and let's get into the actual pattern. First, a quick reminder of what is actually pending, since this entire discussion is speculative unless you understand exactly what triggered it and exactly how far away any actual resolution genuinely is. On June 30th, 2026, the Supreme Court granted certiorari in Viramontes v. Cook County, consolidated with Grant v. Higgins, agreeing to decide whether the Second and 14th Amendments protect the right to possess AR-15 platform rifles and similar semi-automatic firearms. Oral argument is expected this fall, a decision by June of 2027, meaning we are realistically looking at somewhere between 9 months and a year before any of what follows in this video moves from prediction to reality. Nothing has been decided yet. Every state ban currently on the books remains fully enforceable today, exactly as it was before this cert grant. What follows is a forward-looking analysis of what states with these bans are likely to do if the ruling goes against them, grounded in how they have actually responded to prior, similar rulings. Not a prediction that this outcome is certain or even necessarily likely, since the court could just as easily rule the other way and uphold these bans instead, in which case most of what follows in this video would simply become moot. Here is the first, most important pattern worth understanding because it already happened once this year in a related but different case, giving us a genuinely recent, well-documented example rather than having to reach back years for a comparable precedent. When the Supreme Court struck down Hawaii's default consent carry law in Woolford v. Lopez back in June, gun control advocacy organizations did not respond by conceding the underlying policy goal, keeping firearms out of businesses that did not want them present. They pivoted immediately, within days of the ruling coming down, toward the one tool that ruling left completely intact, encouraging individual businesses to voluntarily post their own no firearms signage, distributing template signage and guidance to member businesses across the affected states almost as soon as the opinion was released. That specific, documented response is the clearest possible preview of the general pattern likely to repeat if Viramontes goes the same direction on assault weapons specifically, a shift away from the tool the court closes off toward whatever adjacent tool remains available, executed quickly and deliberately rather than as a slow, uncertain adjustment over months or years. Now let's get into the specific regulatory tools states are most likely to reach for if outright rifle bans become constitutionally unavailable, because several of these are not hypothetical, they already exist in some states right now, operating alongside the rifle bans rather than replacing them, meaning the infrastructure for a pivot is already partially built in several jurisdictions well before any ruling actually forces the issue. Walking through each of these tools individually, rather than treating alternative regulation as one undifferentiated category, is the actual point of the rest of this video, since each tool faces its own distinct legal exposure and its own distinct political feasibility depending on the specific state considering it. Magazine capacity restrictions are the most obvious candidate, and the most immediately available one, since roughly 13 states already have some version of this tool in place, a broader group than the roughly dozen states with full rifle bans, meaning the regulatory infrastructure and legislative precedent for this specific tool already exists well beyond just the states currently defending outright rifle bans. If a state loses its ability to ban a rifle platform outright but retains its ability to restrict magazine capacity, the practical effect on how that rifle can actually be used shifts meaningfully even without banning the rifle itself, since a rifle without an available high-capacity magazine functions differently in practice than one with unrestricted magazine access, limiting the number of rounds that can be fired before a reload becomes necessary. This is exactly why the Department of Justice's own Second Amendment section has already filed a separate lawsuit specifically targeting Colorado's magazine restriction, distinct from any rifle ban, treating this specific tool as its own independent target rather than assuming a win on the rifle question would automatically resolve the magazine question too, a strategic choice that itself signals the DOJ anticipates exactly the pivot. This entire discussion is describing and wants to close off that alternative avenue preemptively, rather than waiting for states to actually attempt it after losing on the rifle question specifically. Purchase age restrictions are a second, already active tool, and one that survived legal challenges even in states where broader rifle bans faced more serious difficulty, making it a comparatively lower-risk pivot for any state legislature weighing its options after an adverse ruling. Several states, including Virginia as part of its 2026 legislative package, raised the minimum age to purchase a rifle to 21, aligning it with the existing federal minimum age for handgun purchases, closing what lawmakers in several states have specifically referred to as a loophole allowing younger buyers to access rifles, even where handgun purchases already required a higher minimum age. This kind of age restriction targets a different constitutional question than an outright category ban, one closer to questions already addressed in other Second Amendment litigation about age-based restrictions generally, where courts have generally shown more willingness to uphold reasonable age minimums than outright category-based ownership bans. And it is a tool states could plausibly expand or tighten further even in a world where Viramontes strikes down category-based rifle bans entirely, since raising an age minimum from 21 to some higher threshold would represent an incremental tightening of an already established, already litigated tool, rather than an entirely novel legal theory requiring its own multi-year litigation cycle to test. Enhanced background check and permit-to-purchase requirements represent a third pivot option, shifting the regulatory burden from the object itself, the rifle, to the transaction, the purchase, a distinction that matters enormously for how courts have generally evaluated these kinds of requirements under the historical tradition test. Several states already require additional background check steps, waiting periods, or purchase permits specifically for rifles meeting certain feature definitions, layered on top of, or sometimes instead of, an outright ban, meaning the infrastructure and legal precedent for this specific tool already exists in parallel with the more aggressive category bans currently facing Supreme Court review. If the underlying category ban becomes unavailable, expect states to lean harder into extending or tightening these transactional requirements instead, since a waiting period or an enhanced background check step targets a meaningfully different constitutional question than banning ownership of the object outright, one focused on verifying eligibility rather than categorically prohibiting an entire class of otherwise eligible buyers from ever completing the purchase at all. Insurance and liability-based approaches represent a genuinely newer, less legally tested direction, one that has been discussed more in policy circles than actually enacted at scale, but worth understanding because it represents exactly the kind of creative, indirect approach states have turned to before when a direct regulatory tool became unavailable. This could take the form of mandatory liability insurance requirements tied to ownership of specific firearm categories, or expanded civil liability exposure for manufacturers, sellers, or even owners under specific circumstances, an approach that shifts the regulatory pressure toward the economics of ownership rather than the legality of ownership itself, making a firearm more expensive or more legally risky to own without technically prohibiting ownership outright. This kind of approach faces its own separate legal challenges, since a state cannot simply relabel a functional ban as an insurance requirement and expect it to escape the same constitutional scrutiny, a lesson states have already learned the hard way with default consent carry laws like Hawaii's, which the Supreme Court looked through to the practical substance of the mechanism rather than accepting its formal legal label, a precedent that should give any state considering an insurance-based workaround real pause about how a court would likely evaluate a similar attempt to achieve the same practical outcome through different formal packaging. Safe storage requirements represent a fourth, already partially deployed tool, one that targets how a lawfully owned firearm must be kept rather than whether it can be owned at all. Several states, again including Virginia's 2026 package, have expanded safe storage mandates for households with children, a tool that survives even in states where broader ownership restrictions face serious legal jeopardy, since storage requirements target a genuinely different constitutional question: reasonable regulation of an already owned item, rather than a restriction on acquiring it in the first place. A distinction that has generally allowed storage requirements to face considerably less aggressive legal challenge than outright category bans, even from the same gun rights organizations actively litigating against the broader ownership restrictions in the very same states. Here is the important caveat running underneath every one of these predicted pivots, and it is worth taking seriously rather than treating this entire discussion as a foregone conclusion or a guaranteed roadmap. Every one of these alternative tools faces its own independent constitutional exposure under the same historical tradition test the Supreme Court has been applying consistently since 2022's Bruin decision, meaning none of them represents a genuinely safe, litigation-proof alternative simply because it has not yet been the specific subject of a major Supreme Court ruling. A state that successfully pivots from an outright rifle ban to an aggressive magazine restriction has not necessarily found a legally safe harbor. It has simply moved the fight to a different specific provision, one that will itself eventually face its own version of exactly the litigation currently working through Viramontes on its own separate timeline, with its own separate set of plaintiffs and its own separate historical arguments to test, potentially reaching the Supreme Court itself again in a future term once enough lower court litigation has developed a sufficiently clean record. The Department of Justice's own Second Amendment section, through its Colorado lawsuit specifically targeting magazine capacity, is already signaling that this next fight is not a hypothetical future concern. It is already actively underway in parallel with the rifle ban question itself, meaning the pivot this discussion predicts and the legal challenge to that same pivot are, in at least this one instance, already happening simultaneously rather than sequentially. There is a specific, real-world preview of this exact dynamic worth understanding in more detail, because it already happened this year in a directly related context, offering a genuinely live current example rather than a purely hypothetical scenario. Virginia's own 2026 legislative package did not rely on a single tool. It combined several of these approaches simultaneously: an outright rifle and magazine ban, a raised purchase age, expanded safe storage requirements, and a separate measure restricting how firearms can be left visible in an unattended vehicle. A genuinely comprehensive, multi-pronged legislative strategy rather than a single isolated bill. When the rifle ban specifically ran into serious legal trouble, blocked by injunctions within days of taking effect following 4 separate state lawsuits, a federal lawsuit, and a Department of Justice suit filed the very day the law took effect, the other, narrower measures in that same package, the vehicle visibility rule specifically, faced no comparable legal challenge at all, continuing to operate as written without a single lawsuit filed against it as of this recording. This is a live, current example of exactly the pattern this entire discussion predicts: a legislative package containing multiple tools of varying legal vulnerability, with the broadest, most category-based restriction facing the most serious legal exposure, while the narrower, more targeted measures sitting alongside it proceed largely untouched. A genuine natural experiment playing out in real time within a single state's own legislative package, showing exactly which kinds of tools survive legal scrutiny and which ones do not, months before Viramontes itself is even argued. So, here is what I would actually watch for, specifically in the months following a Viramontes ruling that goes against the current bans, if you want to track how this pivot actually plays out in real time, rather than waiting to be surprised by it months or years later. Watch state legislative sessions in the affected states for new bills specifically targeting magazine capacity, purchase age, or enhanced background checks, introduced quickly after any adverse ruling, since state legislatures generally do not wait long to respond to a major setback on a policy priority they still support. And the specific bill language introduced in the first legislative session following any ruling will tell you a great deal about which pivot each individual state actually intends to pursue. Watch for expanded state attorney general activity specifically defending whichever adjacent tools remain constitutionally available, since state legal resources tend to concentrate wherever the strongest remaining legal ground actually is, meaning a state's own litigation priorities after a loss on the rifle question will themselves signal which alternative approach that state's own legal team considers most defensible going forward. And watch specifically for how the DOJ's own Second Amendment section and private gun rights organizations pursuing the same underlying legal theory respond to any new pivot legislation, since their response, sue immediately or wait and monitor, will itself signal how legally vulnerable each new adjacent tool actually appears to be, given how quickly and aggressively that same office has already moved against Colorado's magazine restriction specifically, well before any final ruling in Viramontes itself. It is also worth watching for a genuinely different kind of response, one less about new legislation and more about enforcement posture, a quieter and considerably harder to track shift than a new bill working its way through a state legislature. Some states may choose not to pass new affirmative legislation at all in the immediate aftermath of an adverse ruling, instead focusing enforcement resources more heavily on whatever adjacent tools already exist on their books, effectively achieving through emphasis and enforcement priority what they can no longer achieve through an outright category ban, without ever needing to survive the political and legal scrutiny that comes with introducing an entirely new bill. This quieter form of pivot is harder to track than a new bill working through a legislature, since it shows up in budget line items and staffing decisions rather than in a bill number you can simply follow through a legislative session, but it is worth watching for in state budget allocations, agency staffing decisions, and public statements from state attorneys general about enforcement priorities in the months following any ruling, since a state can meaningfully shift its practical regulatory posture without ever passing a single new law, simply by choosing where to direct existing enforcement resources and where to concentrate its own legal team's limited time and attention going forward. Step back and look at what this entire pattern actually demonstrates about how regulatory fights evolve after a major constitutional ruling closes off one specific tool, a pattern that shows up again and again across genuinely different areas of law, not just this one specific fight over rifle ownership. A Supreme Court ruling on a narrow, specific legal question rarely ends the broader underlying policy debate entirely. It reshapes which specific tools remain available to pursue that same underlying goal, and states committed to a particular policy outcome generally do not simply stop pursuing it. They redirect toward whatever adjacent tool the ruling's specific reasoning did not foreclose, sometimes successfully, sometimes only until that adjacent tool faces its own eventual legal challenge. This is not a partisan observation about one side persisting against the other's wishes despite losing a case. It is simply how regulatory fights in a federal system with multiple overlapping levels of government consistently tend to unfold in this area of law and in plenty of others, whenever one specific legal avenue closes while the underlying policy disagreement driving it remains genuinely unresolved between the parties who actually disagree about the underlying goal, not just the specific legal mechanism used to pursue it. This pattern also tells you something worth remembering about how to actually follow a story like this one over the coming years. Rather than treating any single ruling as the final word on an entire area of policy that simply resolves and disappears from the news cycle once decided. If Viramontes strikes down the current rifle bans, the honest, accurate headline is not that this fight is over. It is that this specific chapter of the fight is over, and a new chapter, fought over magazine capacity, purchase age, insurance requirements, and storage mandates, is already beginning. In some cases has already begun before the first chapter has even formally concluded, running in parallel with the still pending Supreme Court case rather than waiting politely for it to finish first. Treating a single ruling as a clean final ending in either direction misses the actual ongoing structure of how this kind of policy fight genuinely plays out over years, not months, and understanding that structure now, before the ruling even comes down, puts you in a considerably better position to actually follow what happens next than waiting to be surprised by a pivot that, based on every available precedent, is already the more likely outcome than a clean, permanent resolution in either direction. If this gave you a real, grounded preview of what actually happens next, rather than treating a potential ruling as a clean, final ending to this entire fight, hit like so it reaches other people trying to understand this as an ongoing, evolving story rather than a single closed chapter that resolves everything at once, and subscribe if you have not, because I will be tracking exactly this pivot, state by state, the moment any ruling actually comes down, comparing the real legislative response against the predictions I just laid out to see which of these tools states actually reach for first, and which ones prove more durable against their own eventual legal challenges. This is not a story with a single ending, and treating it as one, in either direction, whether celebrating a ruling as a final permanent victory or mourning it as a final permanent loss misses the actual ongoing structure of how this specific fight and fights like it genuinely play out over years. Tell me in the comments which of these alternative tools, magazine limits, purchase age, insurance requirements, or storage mandates, you think is most likely to become the next major legal battleground, because that tells me exactly where to focus the most detailed tracking once this story actually moves into its next phase, whenever that next phase actually begins.